Greetings and welcome. Today we finish our treatment of the movement for women's suffrage, for the universal right for women to vote in the United States. And we conclude our consideration of the efforts of Susan B. Anthony to bring about a change in law in the United States that would permit women to have the right to vote. In 1872, Susan B. Anthony had arrived at a conviction that American citizens were guaranteed the right to vote by the 14th Amendment. This was a theory put forward by other leaders of the suffrage movement, and Susan B. Anthony decided to pursue a strategy of using that legal argument to justify her right to vote. And so she determined that she would make an effort to vote during the presidential and congressional election of 1872. She went to her place of registration in the city of Rochester, New York, and requested permission to register to vote. And to her surprise, she was permitted to register based on the confident assertion that she made that she had that legal right based on the 14th Amendment. She then went forward and voted in the 1872 election. And interestingly, once the news was shared that she had been permitted to register, another dozen or so women also undertook to register, and many of them also voted in the 1872 election. She was subsequently charged with violating the 1870 Federal Enforcement Act, which makes it a federal crime to vote in congressional elections if the voter was not qualified to vote under state law. This was a curious way of bringing federal charges against a voter or a citizen or a non-qualified voter based on state law. Her legal theory was that the 14th Amendment already secured the right to vote for all citizens without regard to sex. But there were legal objections to holding the trial in Rochester, and the trial was moved to another town in upstate New York. And the trial judge was a man named Ward Hunt, who was also a recently appointed Associate Justice of the U.S. Supreme Court. There is a legal curiosity in this trial because a trial in which a sitting member of the Supreme Court is the presiding judge cannot be appealed to the Supreme Court. So this was to be the final hearing which Susan B. Anthony was able to have. Hunt demonstrated a remarkable lack of judiciousness in his handling of the trial. He early on ruled that Susan B. Anthony could not testify on her own behalf. Secondly, he wrote his opinion before testimony had been given. At the conclusion of the trial, when it was being presented to the jury, he produced a set of handwritten notes in which he had already prepared his statement to the jury as judge. He then instructed the jury to return a verdict of guilty, which violated Susan B. Anthony's constitutional right to a trial by jury. The U.S. Constitution guarantees that in circumstances of a felony criminal charge against an individual, that person has a constitutional right to trial by jury. And Judge Hunt, or Justice Hunt, had made that impossible because he removed the opportunity of the jury to express its own finding of guilt or innocence. Here are the instructions which he gave to the jury, quoting from Hunt's statement: "Assuming that Miss Anthony believed she had a right to vote, that fact constitutes no defense if in truth she had not the right. She voluntarily gave a vote which was illegal and thus is subject to the penalty of law. Upon this evidence, I suppose there is no question for the jury, and that the jury should be directed to find a verdict of guilty." This meant that Anthony's plan to have the jury nullify the law was not even given a chance to be successful. And she had given dozens of speeches around the district to make the argument that the law under which she was being prosecuted was an unjust law and that members of the jury should find her not guilty for that reason. Her attorney had failed her in his defense. He had not anticipated a directed verdict, which frankly, he had no reason to anticipate, because this action was clearly not permitted by the Sixth Amendment of the Constitution. And all that he was able to do was to make a, as it turned out, meaningless motion asking for a new trial. The presiding judge had refused to permit the jurors to be polled. This series of decisions made it impossible for Susan B. Anthony to achieve her central goal, to convince the jury to find her innocent in spite of the law under the theory of nullification, because the jury never got a chance to speak. This was, in the opinion of many observers then and now, an injudicious and shameful act of judicial preemption of the right of jury trial by the judge. Her attorney, Selden, requested a new trial on strong grounds, including her right to a jury trial. This was peremptorily denied. She was then fined, and she rose to say that she had no intention of paying the fine, and the trial was over. Before she was sentenced, Susan B. Anthony gave what might have been the finest speech in her long life of speech giving. Before imposing sentence, the judge asked her whether she had any remarks to make, and she rose to her feet and said, "Yes, Your Honor, I have many things to say. For in your ordered verdict of guilty, you have trampled underfoot every vital principle of our government. My natural rights, my civil rights, my political rights, my judicial rights are all alike ignored. Robbed of the fundamental privilege of citizenship, I am degraded from the status of a citizen to that of a subject. And not only myself individually, but all of my sex are, by your Honor's verdict, doomed to political subjection under this so-called form of government." She continued and eventually concluded her remarks by saying, "May it please the court to remember that since the day of my arrest last November, this is the first time that either myself or any person of my disenfranchised class, that is, women, has been allowed a word of defense before judge or jury." She also explained her legal theory, which she had hoped to be able to present to the jury. "When I was brought before your honor for trial, I hoped for a broad and liberal interpretation of the Constitution and its recent amendments that should declare all United States citizens under its protecting aegis. That should declare equality of rights, the national guarantee to all persons born or naturalized in the United States. But failing to get this justice, failing even to get a trial by a jury not of my peers, I ask not leniency at your hands, but rather the full rigors of the law." She was then sentenced to a fine of $100 by Justice Hunt, and her speech in response to that was also provocative. "May it please your honor, I shall never pay $1 of your unjust penalty. All the stock and trade I possess is a $10,000 debt incurred by publishing my newspaper, The Revolution, 4 years ago, the sole object of which was to educate all women to do precisely as I have done, rebel against your man-made, unjust, unconstitutional forms of law that tax, fine, imprison, and hang women, while they deny them the right of representation in the government, and I shall work on with might and main to pay every dollar of that honest debt, but not a penny shall go to this unjust claim." So she was adamant that she would engage in civil disobedience and not pay the fine which had been adjudged against her as a result of her guilty finding. Her trial never came to closure on the defense based on the 14th Amendment, but in fact there was a trial within the next 6 months which completely and conclusively brought that defense to a close also. The 14th Amendment strategy failed when the minors succeeded in bringing a case based on this reasoning to the Supreme Court, and the Supreme Court rejected the argument unequivocally and unanimously. Quoting from Naparstek, "The new departure, this strategy, was a failure. The plan proposed by Virginia and Francis Minor to win the right to vote for women by challenging the exclusion of women from polling places by claiming the 14th Amendment guaranteed female suffrage had been tested and lost irrevocably. And ironically, Justice Hunt was one member of the Supreme Court which found unanimously against this strategy. So something new was needed as of 1873. The movement for women's suffrage was not willing to take defeat, and it had to arrive at a new strategy. And there seemed to be three strategies worth considering. First, to seek reversal from a new Supreme Court case, which seemed very unpromising given that it was a unanimous and unequivocal decision in the minor case. Second, to work methodically with each legislature of states in the Union to seek change in each state legislature to establish the right of women in that state to vote in all elections. A laborious strategy, but one which could be pursued. And then third, the third strategy, to pursue a constitutional amendment parallel to the 15th Amendment, which guaranteed African American males the right to vote, but to pursue a constitutional amendment strategy guaranteeing women's right to vote. Even though the constitutional amendment strategy had been considered to be the least likely, under current circumstances, it was now judged to be the most likely. The most famous three words that Susan B. Anthony ever uttered, she gave to a person who interviewed her: failure is impossible. And the strategy to have an amendment guaranteeing women's right to vote in the United States was undertaken within a few years of the defeat of Susan B. Anthony in court. Here is the 19th Amendment. It's a very short amendment. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have power to enforce this article by appropriate legislation. The 19th Amendment was brought forward. It took decades to be passed by the Congress, and after long failure, the amendment gained support from President Woodrow Wilson during World War I and was affirmed by the U.S. House and Senate in May and June of 1919. The 19th Amendment to the Constitution received final ratification by the requisite number of states when the Tennessee legislature ratified the amendment by a single vote in August 1920, just a little over 100 years ago. 72 years of struggle had transpired since the Seneca Falls Convention in 1848, and now women had a federally guaranteed constitutional right to vote. Was this the end of the struggle for equal rights for women? Well, it certainly was not. The 19th Amendment did not establish equal rights for women in all spheres, and within 2 years of the ratification of or 3 years of the ratification of the 19th Amendment, Alice Paul, the leader of the National Women's Party, drafted something that came to be known as the Equal Rights Amendment. The Equal Rights Amendment reads in 3 sections. Section 1, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Section 2, the Congress shall have the power to enforce by appropriate legislation the provisions of this article. And number 3, this amendment shall take effect 2 years after the date of ratification. The Equal Rights Amendment was vigorously opposed at the time and then subsequently by a conservative reaction against women's rights, including in the 1970s, a movement by conservative women against ratification of the ERA. So what has occurred with gender equity since the right to vote, universal right to vote, and a rising level of attention to gender equality and the importance of equality between men and women? Well, here's a McKinsey report on gender equity, which is, I think, a very interesting and a very timely finding. They look at some 11 aspects of gender equality: women's labor force participation, the types of jobs held by women, the number of women in leadership positions, the amount of unpaid work done by women, the number of single mothers, the level of maternal mortality, the participation of women in higher education, rates of teen pregnancy, women's political representation, and violence against women. The McKinsey investigation examines these, looks like 11 different characteristics, and on that basis, they give a rating for each state in the United States of the level of gender equity. And as you see it in the following slide, the level of gender equity is nowhere near parity. In each state in the Union, there is a discrepancy between men and women with respect to these 11 characteristics, ranging from a low of about 0.58 female to men performance on these measures to a high of something like 0.7, just eyeballing this slide, 0.70 in New Hampshire, 0.74 in Maine. So clearly, the struggle for gender equity is not yet finished. Gender equity is not established in our country. But the struggle for equal voting rights for African Americans and some women is also not yet finished. And so I want to close today by looking at limitations on voter participation and voter registration, which have been a part of our political history since the 1950s. Beginning during the Civil Rights epoch in the 1950s and in the post-Reconstruction period of the South, after African American people were guaranteed the right to vote, Southern states enacted a variety of obstacles to participation in the electoral process. Various means were adopted in the Jim Crow South to prevent African Americans from exercising their voting rights, including fraud, misrepresentation of what those rights were, poll taxes, literacy tests, restrictive and arbitrary registration practices, and, of course, through the Ku Klux Klan and other violent white racist organizations, intimidation and violence were directed at black citizens, men and women, attempting to register to vote in Mississippi, Alabama, Louisiana, and other states. This is the reason why I asked you to view the video last week of voter registration challenges in Mississippi, Alabama. Here we have a voter registration form from Mississippi in 1955, which is clearly designed to exclude African American citizens from registering to vote. You'll need to look at this form on the slides that are also posted, but basically you will see that this registration form is obviously and transparently designed to make it impossible or extremely difficult for African American people, rural people, often poorly educated people, to prevent them from exercising their rights of political participation, and to provide a legal basis for excluding them from voter registration if they did make the effort to register. And as you probably know from what you know about the history of the civil rights movement in the 50s and 60s, voter registration was a very important part of the efforts at racial equality which were occurring in the 50s and 60s. If you look at the registration form on the previous slide, you will see that it's very complicated. It requires a series of answers to questions about previous residences and employment, and it requires the applicant to provide an interpretation of the meaning of an assigned clause of the Mississippi Constitution. The registrar had the ability to rule that the explanation that the applicants provided was not a, quote, reasonable interpretation, and therefore disallow their application for registration. And finally, the applicant is forced to endorse Clause 209 of the Mississippi Constitution. Separate schools shall be maintained for children of the white and colored races. In other words, in order to register to vote, a prospective voter had to acknowledge the legal legitimacy, the moral legitimacy of segregation in schools. As I think you know from watching the news, voter suppression, interfering with the right to vote of various groups of people of color, urban people, and other groups in this country, that those efforts at voter suppression are still a part of our political process in many parts of our country, and therefore the work of women's suffrage and full rights of participation for African American, Latino American, Hispanic American people throughout our country is still unfinished.